Interstate Water Disputes Essay. Essay on interstate water disputes for students and children in English. According to section 17 of the state list, water is a state subject and consequently states are enabled to enact enactment on water. Constituent Assembly foresaw the development of water disputes in the future. A particular arrangement of Article 262 is referenced Constitution itself because of the effectibility of such conflicts. Parliament may by law accommodate the mediation of any question or grievance concerning the utilization, dispersion, or control of the waters of or in any interstate waterway or stream valley. Despite anything in this constitution, Parliament may, by law, give that neither the Supreme Court nor some other court will practice purview regarding any such debate or protest. Accordingly, it very well may be seen that the goal of the water question is represented by the Interstate Water Disputes Act 1956. As indicated by its arrangements, a state government can move toward the center to elude the problem to a court, whose choice is viewed as last. Waterway, water use, outfitting is remembered for state purview, section 17 of state list, schedule 7 of Indian Constitution. Nonetheless, the association government can make laws on guidelines and improvement of interstate waterways and stream valleys when practical in the public interest, section 56 of the association list, schedule 7 of the Indian Constitution. When public interest is served, the President may likewise build up an interstate chamber according to Article 263 to ask and suggest the question that has emerged between the states of India. IRWD Act, Section 2C2 approves the past arrangements assuming any among the bowl states to tackle an interstate waterway or stream valley. This act is kept to the states of India and not relevant to association regions. Just concerned state governments are qualified to partake in the council arbitration and non-government elements are not allowed. Commonly, there have been phenomenal deferrals in establishing the court. For instance, on account of the Godavari water contest, the solicitation was made in 1962. The court was established in 1968 and the honor was given in 1979, which was distributed in the Gazette in 1980. Additionally, in the Kaveri water dispute, Tamil Nadu government mentioned comprising the council in 1970. Thoroughly after the intervention of the Supreme Court, the committee was established in 1990. Because of postponement in the court, state governments kept on putting assets in the development and alteration of dams, subsequently reinforcing their cases. India has 2.4% of the world's territory and 18% of the total population. However, just 4% of the inexhaustible water asset. If promising advances are not taken, the lopsided water appropriation will build the chance of water clashes. Interstate waterway water disputes upset our country's helpful federalism and give a parochial attitude, making regional issues better than public matters. One ought to understand that our country is a family wherein all states are its individuals. So disputes must be settled by discourse and talks, and the political advantage must be kept away from it. The issue can be resolved by examining the contest in interstate council, which can give a stage to the discussions. Such disputes must be settled ahead of schedule as conceivable to guarantee more prominent participation between the states.